You're listening to the Multifamily Marketwatch for Washington State. Apartment owners who need to know, trust HFO. The leading source for multifamily industry news around the state, from Puget Sound to the Tri-Cities.
Welcome back to Washington Multifamily Marketwatch. I'm your host, broker Aaron Kirk Douglas. With me today is Quinn Posner, owner and attorney for Northwest Landlord Solutions. Thanks for joining me today, Mr. Posner.
Thank you for having me. I'm excited to be here with you today.
Well, can you tell me a little bit about your business and what you specialize in here?
Sure. I've been an attorney here in Clark County, Washington, licensed in Washington and Oregon since 2001. I got involved in the landlord-tenant space back in the beginning of 2013 and have built my practice to the point where I believe we are the premier law firm to assist landlords. We do not assist tenants. And we do what we can to do a great job for our landlord clients and to keep them abreast of where things are going legislatively, procedurally within the county, and really to make sure that if a client comes to us with a problem that many landlords have, that they're able to work through it quickly and efficiently.
Can you tell me what you're spending most of your time on these days?
Well, since the pandemic, we've really been spending a lot of time, obviously, on unlawful detainers. That is where the lion's share of our work is right now, because we're still working through some of the backlog that occurred due to Governor Inslee's moratorium. That moratorium went into place in March of 2020. And while Governor Inslee at the end of June did say, hey, the moratorium's done, but I'm going to have a little bridge extension here. There's a few hoops you need to jump through, but you cannot, if you jump through these hoops, you could otherwise file an unlawful detainer for non-payment. Mm-hmm. Okay, there was a few other things that were allowed. However, in Clark County, we were effectively under a moratorium until November for non-payment cases, which was going to be the lion's share coming out of the pandemic, just due to the fact that a lot of people weren't paying rent for that year and a half. And the reason why we were delayed several months compared to other counties in the state is because under Governor Inslee's bridge extension, you had to have what was coined as an operational rental assistance program in the county. Well, we had Council for the Homeless that was doing that. And I'll tell you, Council for the Homeless was doing a fantastic job in getting money out to people who needed it. Probably one of the best outfits in the state for that at the time. But the problem was it did not meet Governor Inslee's or the Attorney General's definition of operational. And it's my understanding that's because they would open up the portal, would accept a certain number of applications, and then close the portal while they work through those applications. Well, it's my understanding the Attorney General thought that to be operational, you always have to leave the portal open.
Right.
So we're kind of dealing with some things, in my opinion, that didn't make a whole lot of sense. But that's why we were really we were sitting on our hands until November. November came along, and we've started running with cases, and we are still extremely busy with the unlawful detainers. Part of that is with the changes in the Residential Landlord Tenant Act that went into place in 2021. It's really expanded the timelines of how quickly you can work through these cases.
Are you finding that the mediation process that's required is really dragging things out for owners? Well,
let's talk about that process. So part of what happened in 2021, well, let's go back to before the pandemic. Back in the old days, if you had a tenant that did not pay rent in the state of Washington, the Residential Landlord Tenant Act stated you served them a 3-day notice to pay or vacate. That's all you needed to do. Several years ago, that was changed to a 14-day notice to pay or vacate. That was all you needed to do. And right up until Governor Inslee's moratorium, it was simply the 14-day notice to pay or vacate. Well, during the moratorium, the Office for Administration of Courts and the Washington Supreme Court took the opinion that, hey, we're going to have a tsunami of evictions. And I'm sure that's a phrase you've heard across the country, which I don't think is really came out as much as they were saying it was going to.
Right. There were a lot of stories saying, you know, all of these people were going to be on the streets instantaneously. And I felt like, well, let's wait and see what really happens.
Exactly. And I'll tell you, there were some people who had a tough time because of the pandemic and they needed some help. So I understand that. But I do think the vast majority of people who are subject to the unlawful detainers after the moratorium were people that were probably going to be in that process regardless of the pandemic. So what the Supreme Court and the Office of Administration of Courts did during the pandemic is they said, hey, we're going to let you guys have a kind of an eviction resolution pilot program, okay? And this is something that if you serve your tenant with these notices, as soon as the pandemic or the moratorium's lifted, you guys are good to go. Well, there were some notices you needed to serve. That actually got us going in December of 2021. So almost 11 months before the moratorium lifted effectively in Clark County. So we worked those cases for a number of months. I found that the number of tenants who actually wanted to engage with that process was an exceedingly small percentage. Then in the 2021 legislative session, the legislature, I'm presuming, figured, hey, that eviction resolution pilot program seems to be a great deal. We're going to codify that. Not only that, but we're also going to codify the requirement for a reasonable repayment plan. So now, instead of having the 14-day notice to pay or vacate, which is the way it was right before the pandemic, you serve your tenants with the 14-day notice to pay or vacate, which has updated language, and you need to be very careful that you're following the language within the statute. There is the eviction resolution pilot program notice that needs to be served upon the tenant. And then the offer for reasonable repayment plan that needs to be served upon the tenant. And it's very important to speak to an attorney on these things because there are certain things that can be within the reasonable repayment plan offer, things that cannot be in it. And if you don't strictly follow the statute on that, then the service of those notices would be ineffective for you in court.
So they just dismiss your case and you have to start all over again. Essentially,
because you have to remember, this is the way the statutes are drafted when it comes to the Residential Landlord Tenant Act. You have to follow those very strictly. And that is because the Residential Landlord Tenant Act was put in place in 1974, I believe. Prior to that, landlords were looking at ejectments, things like that. So in exchange for having a fast-paced or a fast path to having a tenant removed, landlords basically had to agree, all right, we will comply with these statutes strictly, and they need to be followed correctly. Otherwise, you're not going to be successful. So here's the interesting thing. The eviction resolution pilot program notice is supposed to sunset the end of June 2023. We'll see if that happens, right? Who knows if the legislature decides that, hey, this is a great thing, we're going to keep it around. The offer for reasonable repayment plan is supposed to sunset 6 months after Governor Inslee drops the state of emergency. When is that going to happen? It's been going on 2.5 years now. Most states have dropped it. Governor Inslee has recently said that that COVID is still a threat and he's not dropping the emergency declaration. So up until he does, we don't know when the offer for reasonable repayment plan is going to go away. But getting back to your original question is where I'm seeing the delays. Once these notices are served, you need to provide a copy to the local dispute resolution center. And here in Clark County, that's Community Mediation Services. They will then make 3 attempts to contact the tenants. Okay. And then if they're unsuccessful in doing so, or the tenant chooses not to engage, then we will, the landlord or the landlord's attorney, if an attorney is handling it for you, will then receive a certificate of compliance. The certificate of compliance is the golden ticket to go to court. Until you have that, you are not allowed to file your unlawful detainer. And so where the delays are coming from really is with the dispute resolution centers. I have had cases. They've been much quicker lately as they're working through the backlogs, but I have had cases that took me 4 or 5 months to get a certificate. I know we just contacted the Dispute Resolution Center, I believe it was yesterday, on notices that were sent over there on June 8th. And here we are over 2 months later. We don't have a certificate. We don't really have updates. Now, I know the dispute resolution centers, this has been kind of an unfunded mandate to a certain extent for them. They're having a heck of a time with budgets, keeping enough staff, all of that sort of stuff. So that's where we're seeing a lot of the delays. And that's really what's hurting the landlords. Because once I get that certificate, I can file that unlawful detainer. I'm going to be in in court pretty darn quickly, maybe within a week and a half of filing. But until we receive that certificate, the landlord is still losing another month's rent and another month's rent and another month's rent. That's where we're seeing the biggest delays.
So what are some of the common mistakes you're seeing rental owners making right now? Does it have to do with that mediation and eviction process, or is it something else?
Yeah, I'm seeing. So a lot of my clients, we handle the notice portion because keep in mind, if the tenant wishes to engage with the dispute resolution center, you may have to mediate some sort of settlement. If they wish to make a counter to the offer for reasonable repayment plan and not elect to go through the eviction resolution pilot program, you're going to have some form of a negotiation. So where I am seeing clients, if they come in and they've done it all themselves, and they say, hey, Posner, I'm ready to go. Here's my notices. I may say, well, where's your certificate of compliance? Certificate of what? I don't know what you're talking about. Oh, well, you needed to send all of these over to the dispute resolution center. I've noticed a lot of smaller landlords, more your mom and pops, that weren't aware that they had to go through that process. They just thought you served the notices, but they never sent anything over to do the dispute resolution center. So now they're again, they've got that delay they're facing because then they're going to have to send everything over. Or I may have someone come in and there's a certificate of compliance, but the 14-day notice to pay or vacate that they utilized was not updated pursuant to the 2021 legislation. So then they have to start that process over again. Or maybe they've offered the reasonable repayment plan, but they have put terms in there that are not permitted. One of the major terms that is tripping up landlords is the monthly payments cannot exceed 1/3 of the monthly rent. Well, that's considered the maximum amount. That doesn't mean it's reasonable.
Right.
If you take a look at the tenant's financial situation, work situation, basically what's going on in their life. And some landlords have stuck to, no, the legislature says 1/3 is reasonable. And then you have to say, no, it's not. You may have to go back and negotiate a new deal with the tenants. So that's where I'm seeing a lot of confusion when we're speaking specifically about the non-payment cases. Obviously, there's a host of other new notices where I've seen issues with landlords that have come in where they've served a notice and it's not proper, and some of which may be a 90-day notice. Now they're 3 months further behind. So it's always an excellent idea if you have a good relationship with your attorney. If you're going to do the notices yourself, if you give them a quick call and say, hey, here's how I'm going to do it. Is this okay? And, some attorneys are happy to answer that question quickly.
Okay. What are some of the most common issues facing Washington landlords right now, aside from what we've talked about?
Well, I think one of the major things we are seeing, let's take a look at it statewide as opposed to just specifically here in Clark County. Because in Clark County right now, we're not facing new city codes, to compete with the Residential Landlord Tenant Act. Right. We're pretty much governed by RCW 5918 when it comes to landlord tenant. In many cities, specifically up in the Seattle area, they are codifying new laws that are much more extreme in favor of tenants than the Residential Landlord Tenant Act is or could ever be. And so the problem you have with landlords who may have properties in Federal Way and Burien, Olympia, Seattle, is not only are they maybe, hey, I'm in King County, so I think everything's going to be the same, aside from Tacoma, but the fact that they might have units in different cities, they have to know a host of different laws. It's not all about state law anymore in a lot of these states. And as I was mentioning earlier before we came on the podcast here, there needs to be a real push in the next legislative session for preemption, which basically states, hey, the Residential Landlord Tenant Act is the law of the land for the state of Washington. You got to stop doing all of this. But the only way I can see that happening is if the landlords are going to have to give up some of the protections that they have and are going to have to appease some of these cities that are in the Seattle area. Because as it stands right now, why should a landlord in Burien or Federal Way be expected to jump through so many more hoops, so many more hurdles, so much more cost attached to it, so much more time attached to the process than a landlord in OMAC.
Right.
Because that's the way it stands right now. And unfortunately, everything's being driven, for the most part, in my opinion, out of the King County area.
Right.
And it's going to affect landlords across the state. That includes Southwest Washington.
Well, Seattle has been going a little bonkers with their requirements. What are some of the best ways for rental housing providers to avoid these issues? And it sounds like you're going to tell them to stay in touch with their lawyer, keep them on speed dial, and call them, or, if they're going to do something themselves, at least check in and make sure what they're doing is correct.
Yes. I think the other thing that's very important, if you have a landlord organization in your area, join it.
Right.
I'm the legal advisor for the Clark County Rental Association and have been for 9.5 years now.
Right.
When all of these changes come down the pike, I'm presenting to the association, and there are attorneys for lots of associations that are presenting for associations around the state. Clark County Rental Association, being the one I'm familiar with, if you're a member of the CCRA, you're automatically a member of the Washington Landlord Association. So not only do you get the education through the local organization, but you do through the state organization as well. And you have access to forms.
Right.
So you have a whole form library with updated forms. I know that the Clark County Rental Association has the proper 14-day notice. It has the proper ERPP notice that we're using in this county, which is different than what some other counties are doing.
Right.
And what is considered an acceptable offer for reasonable repayment plan template in this county. And I know that because I'm the one who's updated all of those.
Right.
So these organizations are inexpensive and I think incredibly valuable to landlords because of the updated forms they have access to and the education that they receive that would cost them more if they wanted to go to a landlord attorney and buy an hour of time.
It's well worth the money to join and pay for the forms if you have to buy them. Some I know in Oregon, some of the forms you have to buy individually, others they sell in packets. And so it just depends on what your needs are.
Absolutely. It depends on who you're going through.
Let's see. Can you discuss the case that was filed in the Rental Housing Association of Washington versus the city of Seattle that told Seattle that their ban on accruing interest for unpaid rents wasn't valid?
Well, I don't know too much factually about what's going on, but this brings it back. If you let's look at the Seattle case and look at the Spokane case that's been filed by the Washington Business Properties Association. What this all boils down to again is, hey, we've got state law, and you're basically trying to trump state law with some ridiculous city code provisions.
Right.
So I think that's really what the nitty gritty of it is. And while those lawsuits will continue, and I'm part of them, so I don't know enough about what's going on under the hood, and they've just recently been filed. Although I do know some of the people who are involved with them. We're not going to have a huge fix statewide, in my opinion, unless we're able to do something in the next legislative session. And it's very important to have legislators there that are friendly to landlords, because that's just not the case in Washington the way it used to be.
Okay. Well, and that kind of leads up to the next things that we wanted to talk about, which was, do you have any idea about any specific legislation that's going to be filed in the next session related to those changes in landlord tenant law or anything else?
I haven't seen any draft bills that may be presented in the session as of yet. The main thing that I've been kept up to date on is this push for the state law preempting anything the cities are doing, because that's going to be the major goal for the landlord lobby in the spring, in my estimation.
What do you think they might have to give up in order to get what it is that they want?
Well, you take a look at some of and remember, I don't practice up in the Seattle area, so I don't deal regularly with the statutes. But if you have, let's say you have, and I'm just going to make this up.
Sure.
But because you see this down in Multnomah County or in Portland, but let's say someone's going to be forced to move. Their lease is terminated legally. Well, in some cities, the landlord may have to pay, and I'll just make this number up, but let's say it's, twice what monthly rent is, thereabouts. So let's say monthly rent was $1,500. So the landlord's going to have to pay $3,000 in moving expenses. Well, if that's something that places like the city of Seattle and other legislators out of that area are married to, well, that could be the sort of thing that may have to be built in to the Residential Landlord Tenant Act. Now, I'm just speculating. I don't know what those things might be because I'm not involved in the nitty gritty of what's going on. Aurora is speaking to legislators and some of the behind the scenes things there. But the landlords are going to have to give up on some things to the benefit of tenants that we may be seeing in these other cities, so we can get the legislators from those areas to be on board with saying, all right, the Residential Landlord Tenant Act is going to be the law of the land, but they're going to want those tenant protections built into the statute. And again, we just overhauled a considerable part of the RLTA in 2021. Seemingly all for naught. And all of that was to the benefit of tenants. But then these cities have decided we want to go much further. And so if we want to have one law of the land, the RLTA is going to have to go further, unfortunately, because it's already gone pretty far in my estimation.
There have been a number of cases recently out of California where the courts have ordered some landlords to pay the actual moving expenses of tenants that were evicted legally. I think that happened in Oakland. And I'm wondering whether these kinds of requirements that have the mandatory relocation fees and payments and whatnot, don't they just end up making everyone pay more rent because everybody has to subsidize all those moving expenses that you're paying for everyone else? So in effect, it just ends up causing rents to increase for everyone.
There's absolutely no question that that's what happens. And the reason for that is being a landlord and landlording is a business. No one's doing this to lose money. There are people who charge rents that are under market rate because they may have lower income people who are good tenants and they want to keep good tenants there. And I certainly understand that. But when, as any landlord out there knows, as the government piles on more and more and more regulations and more expenses, you have to charge more for rent. Well, the problem then is you have legislators trying to push for rent control, which is something that we've been able to avoid in the state of Washington. There was a push for it in the last session. Seemingly every session there's a push for it. So it's a bit of a balancing act because you got to be careful. But to your point, there's absolutely no question that it increases rents because this is a business. And what I see, I've had a lot of mom and pop clients who've decided to get out of the business entirely. They've decided that they're done. They're selling. They're going to 1031 into something else, or maybe they're just deciding to take the profits and be done entirely because they just simply...
It's too stressful.
Exactly. And they can't deal with what's going on any longer. And they feel like they have no control over their own property, as you well know. So where I think we're going to end up potentially at one point in this state is you're going to have huge national management companies that manage large apartment complexes, those sorts of things. They are able to absorb some of the cost, and to them, it is a business. There's no mom and pop who has one or two rentals that then forms a relationship with their tenant who've been there for 10 years. That's not going to exist. You're just going to be a unit number at some point. There's going to be less of that. I formed a relationship with you as a tenant and I like you, so I'm going to give you a break on your rent because you do X, Y, or Z, or I know your situation and I appreciate you. The corporations, they aren't going to do that for people. Yeah. And they're not able to. And one of the reasons why they're not able to is also because our fair housing laws. So they need to be very careful of treating tenants differently. Whereas if you have a mom and pop that has one single family home, it's a different story. That's the other thing. You're going to see less and less single family homes offered for rent. It's just not going to be in the inventory because the people that are renting those out or own them for the most part are the mom and pops.
Right.
So that's going to become a much more difficult thing to find, I believe, in the state of Washington at some point in the years to come.
Well, Quinn, do you have anything else you wanted to talk about today? Anything on top of your mind when you're talking with landlords? One
thing I want landlords to be aware of in the state of Washington, because I'm finding many are not aware, but part of the 2021 changes and something that it's been made a huge impact on the court process is we actually have right to counsel now for low-income tenants. Mm-hmm. So here in Clark County, we mainly see our Housing Justice Project attorneys, and we're still a small enough county where we can work with each other one-on-one. It's different than the real litigious scenario that's coming out of Seattle. We do have Northwest Justice Project that gets involved on occasion, but low-income tenants are being assigned a free attorney. Mm-hmm. And I am finding that these attorneys are now trying to come up with a material issue of fact. Whether or not they are or not is another story. But they're trying to come up with something to then to be able to demand a jury trial. Prior to all that, prior to the pandemic, we never once had a jury trial that I can remember in Clark County on an unlawful detainer.
Oh my God.
We are now seeing those being scheduled. And the statute says they have to occur within 30 days of the date of the show cause hearing, and it takes priority over all other civil matters. Well, it's really hard to schedule within 30 days regardless, given calendars of all involved. Yes. And it's something that can really gum up the courts. And not only that, But then the landlord or the client has the expense of paying an attorney to go to trial. Mm-hmm. Then at some point, you need to make a business decision if it's worthwhile or not.
And on that note,
I could stay here for another hour or two, but
well, we'll talk again. Thanks so much for joining me today.
Yeah, well, I appreciate it, and I'll look forward to next time.
All right.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 206-705-5115 or visit our website at hfore.com for more information. HFO is an affiliate of the Global Real Estate Advisor Network.